In a courtroom where every heartbeat echoes against the walls of justice, one name, one mistake, can decide the fate of a lifetime. Between mercy and law, truth and consequence, only the judge holds the final word. This is where destinies are rewritten.
Who is approaching? State your name for the record.
Jason Ellis.
Thank you.
Your Honor, we are asking for an adjournment pursuant to negotiations. We'll also be submitting a motion to have Mr. Ellis be released into treatment.
Probable cause conference will be adjourned November 20th, 2025, 9 a.m.
Your Honor.
Trial will continue. Thank you. Court calls case.
In the tense silence of the courtroom, every name called echoes with uncertainty. Jason Ellis stands once again before the judge, seeking another chance, a moment of hope in a world ruled by order and law.
Not appearing by Zoom. I have paged the courtroom and the hallway. I've received no response from Mr. Collins, although I do know that he has housing security issues. And I'm in contact with him earlier in the week. He indicated he understood date and time and place. But he's not here. I have no explanation for that. I'd ask that if the court issues a bench warrant, that they delay it so that we can try to contact him.
Bench warrant will issue bond 10,000 cash surety. I'm going to have that issue immediately. Don't worry. See, there it is. I'm just happy you didn't ask me for a show cause.
That was going to be.
But not everyone finds their way to the bench. Andre Collins, missing in action, lost between court dates and the struggles of life. The gavel waits, yet his seat stays empty.
Anderson to write on behalf of Eric L.Z. Williams.
Your name, sir? Eric L.Z. Williams.
Thank you.
And I'm looking for my green sheep, and I am asking for an adjournment in this matter, Your Honor.
Probably the same pace in a second release there. Hang on. Did you get him up to us?
I did.
She did?
Yes.
2? She probably owes us 5. Probable cause conference in this matter will be adjourned to November 20th, 2025, 9 a.m.
Yes. Your Honor, may we address bond?
And then comes Eric Williams, calm, yet carrying the weight of his mistakes. The defense pleads for mercy, for a home tether, for a man trying to rebuild his life piece by piece.
He has 4 kids. He will abide by all bond conditions. And with the bridge cars currently being cut off, his family is struggling. His criminal history consists of a driving while license suspended and operating while intoxicated. And these are his first felony allegations, although serious. At the time that they happened, he was very cooperative with the police. So we are again asking for a home confinement tether.
Response.
People would object. This has actually several operating while impaired, but the bigger concern is the allegations here. The allegations are that he fired off several shots either into the air or at a bush. There's some dispute as to where he fired them off. These occurred at his home, so I don't see how home confinement is going to protect the people who live there. I would ask that people would ask.
But the prosecution stands firm. The past speaks louder, gunshots in the night, fear in the neighborhood. Justice cannot turn a blind eye to what's been done.
Your Honor.
The charges as I have them, I understand what the people just said was, but there was a discharge of a firearm toward a building or dwelling which was occupied.
Or in
The bill, got it.
And as the judge delivers the final word, the courtroom exhales, bond denied, fate sealed, until the next hearing. Another day in court, another story of choices, law, and consequence.
reflect, we've had a bench conference in this case. There's been a request for an adjournment in this matter. Court will adjourn probable cause without objection to December 11, 2025, 9 a.m. Bond will at this point continue. Right. Thank you.
Thank you, Your Honor.
sir.
You and staff have a great day.
You do so. Court calls case of the People versus David Knight.
Good morning, I'm Rob Jake on behalf of Mr. Knight.
Your name, sir?
Good morning, Your Honor. David Knight.
Judge, in this matter, we'd like to set an exam.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available. The 8th.
Judge, I have a trial with Judge Kuhnke starting the 17th. Is it possible we can move this out? Or
I can set it the 18th.
this out? Or
I can set it the 18th. I can set it the 25th.
I know, but I can't be here on the 17th. I can, I'll have somebody cover. Wait, let's do it the 17th, Judge.
The 18th, you mean?
I'm sorry, the 18th, yes. And may I address bond when appropriate?
Yes, you may. Let me set preliminary examination in this matter will be set for November 18th, 2025, 9 a.m. That is before Judge. I don't think so.
Judge Washington.
That's before Judge Washington. All right. Chance to bond.
Judge, it's my understanding that my client is self-employed. He's a contractor. He unloads semis. He promises to prepare for all future court hearings. He would ask that if the court does release him, if it has to be, he agrees to a tether. He's in neglect court regarding his daughter. He would like to attend those hearings in person, and he's not a flight risk. Again, he would agree to a tether. He's posted bond on his other matter, so he's asking if the court would allow a PR bond in this matter.
Response.
I would object to any reduction in bond. In this case, he was present with the victim and their child, and the victim, because he had went through her phone and knew she was cheating on him. He then put his hand around her neck and strangled her, broke her phone, and was trying to prevent the victim from leaving the room with her child, or their child. I would object to any reduction in bond this time.
Was he on bond at the time of?
No, he
Other
had
matters
posted, he had
at the time
posted
of
bond. I believe he had posted bond, right?
Yes, sir.
Well, right, but he's.
I'm sorry.
But he's on bond. He had just posted when this allegedly occurred. Is that right?
Yes, Your Honor. He disputes what the prosecutors, what they're stating, but yes.
Understood, but he'll have a preliminary examination to have that looked at. Motion for bond reduction, given those circumstances, is denied. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you.
Thank you, sir. Court does call the case, People versus Thomas Gay.
Your Honor, we have both the people.
Good morning, Your Honor. Christina Saxon for Thomas Gay, who's on my right. Mr. Gay, please state your name for the court.
Thomas Gay.
Requesting an adjournment.
Yes, Your Honor. I understand that there's a possible resolution. The prosecutor and I have spoken and possibly even resolve this before the next hearing.
Probable cause conference will then be adjourned to November 25th, 2025, 9 a.m. That's a Tuesday. Bond will continue.
Thank you.
Court calls case People versus Alicia Allen.
That's spells for the people.
Good morning, Your Honor.
Good morning.
Assistant Public Defender Brian Bowling on behalf of Miss Allen. Can you state your name for the record?
I'm Lisa Allen.
Your Honor, we're asking that this matter be set for an exam. All discovery is complete to my knowledge.
And would the people have their witnesses available the 18th?
We can try to make it here.
Preliminary examination in person will be set for November 18th, 2025. 9 a.m. That is before Judge Moore.
Thank you, Your Honor.
Thank you. Bond continue.
Your Honor, may I address one issue of bond?
You may.
It's my understanding that the last time Miss Allen was before you, denied the request for her to be released to treatment. If it became available, I'd just ask you to reconsider that.
And Your Honor, I'm sure the court recalls when we were here before, I let the court know about my concerns, any change in her treatment, any change in her bond rather, including at least the treatment, which is extremely unusual. But given the fact that this case, she was driving down 94, hitting more, I believe she hit at least one car, if not two cars. And this is an OWI third offense with a child as well in the vehicle. So I'm very concerned about her getting out at all this time.
And has treatment been arranged at all, or?
I don't believe so, Judge. There are other holds that she need to address as well. Just if it became available, we'd like to have her be able to have that opportunity to go into that program.
I mean, certainly if there were treatment available, I'm not going to have a problem. I mean, I have some issues. It's more the manner in which, I don't have a problem with the treatment. I have a problem with the manner in which she's released, making sure that we have enough safeguards and controls regarding her release.
Okay.
So at this time, what I'll do is I'll again deny the request. But if you come up with something, certainly get it to the court and I'll be happy to take a look at it.
Will do. Thank you.
All right. Thank you.
Good job to staff. Thank you, Your Honor.
Thank you. Court calls case People versus Larry Atkins. Or Larry. It's Larry. That's right. It's Larry. It's Larry that people messed up. I'm looking at it and I said, I know it's supposed to be. Man, I'm sorry. Go ahead.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Atkins. Will you state your name for the record?
Larry Atkins. Yes, I know. Okay.
Your Honor, we did finalize a mitigation report that's been provided to the people. They just need an opportunity to review that. Could have an adjournment.
Probable cause conference will be adjourned until November 25th, 2025, 9 a.m. That is a Tuesday. Bond will continue. Thank you.
Yeah. Okay.
Court does call the case People versus Robert Burnett. Three cases.
Assistant Public Defender Sandra White on behalf of Robert Barnett.
Your name, sir? Robert Burnett.
And Your Honor, we were here before and we have identified that two of these cases are duplicate. So we filed, I'll have the case number 3 here in just enrollment. I apologize for the delay. But other than that, I think we are really just having an adjournment for today's matters.
That is correct, Your Honor. We are asking for an adjournment. On one of the cases, 25 F5 5793, we are still looking for media on that case.
On 5793.
Yes, we're still asking for body cams or any available videos.
Okay.
And the other one, I have 2 case numbers because I'm not sure which one is going to be dismissed.
Right. No, I got you. So, but you're ultimately looking for an adjournment on both of the ones that remain.
That's correct, Your Honor. And if I may address bond.
Hang on one moment. Let me make sure my paperwork is right. So probable cause conference in this case will be adjourned to the 20th, November 20th, 2025 at 9 a.m. Bond will, well, yes, I'll address bond in a moment. I just want to get one that's going to be dismissed all set. Is it gonna really matter?
Ultimately, I think it's going to be the, oh my gosh, what am I think it will end up being the 24FB1406.
That will be dismissed?
Yes.
Okay.
But I believe that one, it will be on the paper, but I do think it will be that case.
The 1406?
Yes.
Okay. And I'm assuming there's no objection to the dismissal?
No, Your Honor.
Right. So
No objection.
I'll mark that one as is. If there's some reason that's not it, then we'll deal with that. All right. And then the other case, I will adjourn to that same date of November 20th.
Thank you, Your Honor.
And then Esteban.
Yes, Your Honor. I do believe it was addressed at the last hearing, but Mr. Barnett wants this court to know that he will abide by all bond conditions. I believe one case is over a year old, and he was an addict at that time. He is currently doing Dawn Farms. He's doing it very successfully. He wishes to continue his treatment outside. If he cannot have a PR bond or home confinement tether, he wants to be released for treatment.
And I do think he was in benchmark status at the time of the 2025 case.
Yes, he
That's
was.
my objection the last 5 years.
And that is my same objection. And he was in benchmark status for a period in time. So I'm going to, again, deny the request for a bond modification in this matter. Bond will continue. Thank you.
Will Your Honor consider release to treatment?
Pardon?
Will Your Honor consider release to treatment?
Certainly. I typically don't have an objection to somebody being released to treatment. So the only thing that you have to make sure, I would like a tether on that upon his release because of his failure to appear. And also that if he fails to complete the treatment, that he's returned immediately to the jail.
Absolutely.
All right.
Thank you. Your Honor.
Thank you. Court calls case People versus Emily Bates.
And for order, Assistant Prosecuting Attorney for the people.
Good morning, Your Honor. Kim Dadish on behalf of Ms. Bates, who is on Zoom. Ms. Bates, can you unmute and state your name for the record?
Good morning, Your Honor. My name is Emily Bates.
Good morning.
Your Honor, we are asking for, I know I said one last adjournment last time.
You did.
We are incredibly.
Wrote it down.
Yes,
And I knew you were not truthful.
but the prosecution have offered something even better. So we're just hoping to adjourn a
So
month.
you're blaming it on that?
No, I'm blaming myself
It is-
completely.
It is my fault.
Always my fault.
Oh,
I'll take it.
taking the hit for you.
You get to choose.
How much more time did you need?
4 weeks would be great, Your Honor.
4 weeks?
Yes, or 3 weeks. 4.
So I always thought like I'm like I know I know now like
December 4th,
but
2025, 9 a.m.
Thank you, Your
Okay.
Honor.
Thank you, Your Honor.
Thank you, ma'am. Take care.
Thank you, Judge.
Bond continued. Court calls the case People versus Eduardo Benavides.
That's yourself for the people.
Really, Your Honor, on behalf of Mr. Benavides. Mr. Benavides, state your name for the record.
Thank you. Really? Acting really?
Your Honor,
What?
we
No, it's
are.
okay. Sometimes there are
You know
just
what?
days that way.
I got this privacy screen on my computer. It's hard to see. I got to tilt it the right way. We're asking for an adjournment, Your Honor. We do not have a resolution yet for Mr. Benavides, but we're hopeful that we could get one. He does want us to address bond, Judge.
November 20th, 2025, 9 a.m. Without objection. Yes, Esteban.
And Your Honor, we're asking that Mr. Benavides be given the opportunity to have a PR bond. I do know that there was an issue. He did miss his court dates. The court
He did.
Yep, the court was kind enough to recall the bench warrant, but there was a bond issue relating to testing. I believe there were missed tests.
Yeah.
There were 2 missed tests, and then obviously coupled.
That was after I had canceled his warrant. He then didn't test. Right?
I think that is right, Your Honor. I think I might have,
No, yeah, you had it right. I just want to make it very clear for the record.
yeah, got it. So Judge, Mr. Benavidez reports that he is currently employed. He had been working for the past 90 days before he lost his bond and was subsequently arrested. He reports that he has stable housing. He has family whom he lives with. He does now understand, Judge, the importance of not only coming to court. He has been very active with us in regards to his court dates. He lives in Clinton, Michigan, so he's not very, very local. So it is a bit of a distance, and I can't say that testing was not being done because he could not make it to community corrections, but I know he was having vehicle issues, which is what made him miss court. He knows now, Your Honor, that it's extremely important that he tests as directed by the court, as well as make sure that he communicates with us with any delays in regard to his upcoming hearing.
I don't need a response. Motion for bond reductions tonight. Under the circumstances, bond will continue. Thank you.
Thank you.
Court does call the case. People versus Winona Harvey.
Overwatch Assistant Prosecuting Attorney to the people.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Harvey.
Harvey, can somebody unmute? Can you state your name for me?
Yeah, there she is.
Winona Harvey.
Thank you.
Yeah.
All right, what are we doing?
Your Honor, this is an adjourned competency hearing. I have had a chance to review the competency report. My office has gone over the report with Ms. Harvey. We do not object to the report.
She is still incompetent, but likely to if she's provided treatment.
That is
she currently in her course of treatment regarding that? Or?
that I don't know, Your Honor. The report was not clear that I saw.
My impression, Your Honor, was that she was not. She's still active.
Oh, she is still here. Yes.
She has not been. I don't think she's been found incompetent yet. I think that's what we need to do.
Yes, that's.
I thought this was a review. Hold on a second. I got the wrong one. Okay. All right. Any other additional information?
None, Your Honor.
Your Honor, the people are in receipt of the report as well and have reviewed it. We have no objection to the court allowing us to competency.
This time, the court would find that the defendant is at this current time incompetent to stand trial, but likely to obtain competence within the statutory period. And so when presented with the order, I will sign that, Mr. Gaddy. I will set a review competency hearing for, give me, she's not out of there yet, so give me 90. We'll move it up if necessary.
Judge.
Set a review competency date for February 5th, 2026, 9 a.m. Yes, ma'am.
May I know today's date?
I'm sorry?
May I know what month this is? When I know what's going on? Can I know what's going on? May I know what's going on? Can I know what's going on?
All right, you come back to see me in February.
What month is this?
November.
Can I say, okay, all right.
That's what I'm going to order. And your
Can I get
bond
some
will
paper?
continue.
Can I get
We'll
a paper?
see it.
Can I get a paper from the front desk saying when I go to court?
Yeah, your attorney will give you one.
I'll send you a notice, Miss Harvey.
No, I don't want to notice.
Okay. You won't miss it. Trust me. All right. Thank you.
The court with an order.
Yes. Court does call the case. People versus Anthony Campbell.
Special Officer for the People.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender for Mr. Campbell, who is here to my right. Your Honor, we're seeking a brief adjournment. Mr. Campbell has an assessment scheduled with the 15th District Sobriety Court that may be informative of this matter as well. That assessment is scheduled, I believe.
Does he have a medical marijuana card?
You have a medical marijuana card?
No.
He does not, Judge.
Mr. Allen.
Is there a bond violation report? May I approach?
Progress report, yes.
Your Honor, I thank you for letting me look at the bond form. Mr. Campbell is I believe he has a medical card that is expired. He reports he does have an appointment this afternoon.
He's also here on 2 charges of OWI with occupants under 16, so he really shouldn't be using any substance.
Yes, Your Honor. I'd ask the court to give him an opportunity to continue testing to abstain from marijuana and allow the court to watch these numbers to the extent that they are positive, continue to drift downwards until they hit 0, which may take a brief amount of I think sometimes up to a month to actually zero out if someone has in fact been using. But I'd ask him to allow him to continue to test and address that.
Probable cause conference will be adjourned to November 20th, 2025, 9 a.m. This time, given the defendant's violations, his bond is revoked. No, my bail. Thank you.
Thank you. Your Honor, I didn't catch the adjourned date.
The 20th.
Thank you.
Court calls the case, People versus Nicholas Chalmers.
Trevor May, welcome to People.
Brian Bowling on behalf of Chalmers is approaching, Your Honor. State your name for the record, please.
Nicholas Chalmers.
Thank you.
Your Honor, I'm asking for an adjournment in this matter. Mr. Mayville and I are working to get a video issue ironed out, which I think we've resolved.
You think
we just need to get it over to my office.
Got it.
And then I'd like to address bond if I may.
Probable cause conference will be adjourned to November 20th, 2025, 9 a.m. Yes, as to bond.
Your Honor, my understanding, the current bond in this matter is a $10,000 bond that was set when Mr. Chalmers missed court back in early October. He's been in custody for 9 days since surrendering himself on that bench warrant. He does reside in Ypsilanti with his grandmother. His mother's here in the courtroom today to provide support to him. He does have a 5-year-old son, and he does work at FedEx. He's hoping that job will still be waiting for him when he leaves custody, whenever that is, hopefully today. I'd ask you to consider reinstating the personal bond that was originally set in this matter. If no objection to a tether, if you feel that that is appropriate.
Why did he miss this court date?
I got the days messed up. I'm sorry, Your Honor.
That sounds like a FedEx issue. Got the days messed up.
Yeah.
And he came back into custody because he turned himself
in.
He
did turn himself back in, Your Honor, to his credit. And like I said, he's been in custody for 9 days since then. I'd ask the court to give him another chance. This is the 4th PCC. To my knowledge, he had appeared for all prior ones prior to the one in October. And he's here today.
Yes, he is. Thank you, Mr. Bowman.
You're welcome, Judge.
Response on your people.
Under the circumstances, I'm not objecting, Your Honor. The defendant has a very limited criminal history. However, what is on there, though petty, is from out of county and shows failure to appears on both of those files as well in its past. So I just wanted to make a note that eventually the courts are going to start taking note of that, but no objection.
All right. I'll reinstate his previous bond, but he cannot be released without a GPS locating.
Wonderful. Thank you, Your Honor.
You understand that, sir?
Yes, I do, Your Honor.
I'm just going to tell you this. I'm doing this, and I dare you not to show back up. Understood? Understood. All right. You do that.
Thank you.
Thank you.
Thanks, Judge.
Yes. Court calls the case People versus Shane Campbell.
Prosecuting attorney to the people.
Camera gathers on behalf of Mr. Campbell, who is on Zoom. Mr. Campbell, can you please state your name for the record?
Shane Campbell.
Thank you, sir.
Your Honor, we are going to be requesting a short adjournment to continue plea negotiations. There also is a potential conflict, so
There's what?
potential conflict.
We don't know yet,
It was very recently.
but that all goes through Mr. Brown. Did you ask him?
It's on me. It's not on Mr. Brown.
You're just trying to take the hit.
Yeah.
Not working.
It was very recently discovered, Your Honor. I believe this is Mr. Campbell's first PCC.
Okay. I want to blame Lauren for something, but everybody's covering it. Probable cause conference, I'll adjourn it to November 25th, 2025, 9 a.m. Hopefully they'll have everything worked out. Okay, Mr. Campbell, that's a Tuesday. All right, sir?
I have a different court date on the 25th.
Where?
Dearborn Heights or Dearborn.
Like them better than me?
No.
No. I don't answer. Don't answer that. What I'll do then, after that, we go through the holiday. I'll make it December 4th.
Thank you, Your Honor.
2025. All right, sir. All right. Thank you, Mr. Campbell. Court calls the case People versus Ishmael Davis.
I'm Tom Walker, assistant prosecuting attorney to the people.
Your Honor.
I sat there. You were sitting there all morning.
I know.
And I go, where is he?
Just
go ahead.
When quick questions pop up, you know.
Yeah, I know.
Your Honor, we are just, this Assistant Public Defender Jay Bellinger on behalf of Mr. Davis. We were just asking to set this for preliminary examination at this time. All discovery is complete to the best of my knowledge.
All right. And would people have their witnesses available the 18th?
We should be.
Preliminary examination in person, November 18th, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
We'll be in touch, okay?
Yeah.
All right. Thank you, Your Honor.
Court does call the case of the People versus Dylan Chapman.
Assistant Public Defender Jay Bellinger on behalf of Mr. Chapman, who approached us. Mr. Chapman, can you state your name for the record?
Dylan Chapman.
Thank you. All right. You're requesting an adjournment.
I am, Your Honor. I unfortunately have no discovery in this case at all at this time. I understand they're working with new systems, but we are trying to get that as fast as possible.
November 25th, 2025, 9 a.m. Bond continued. That is Tuesday. All right. Okay.
Thank you.
Thank you, Your Honor.
Court calls case People versus Clinton Donald.
Assistant Public Defender Jay Bellinger on behalf of Mr. Donald. And
Clinton Donald.
Thank you.
Your Honor, this is another situation in which we unfortunately just have no discovery at this time, so I would ask for an adjournment.
Probable cause conference will be adjourned November 20th, 2025, 9 a.m. Bond continued.
Your Honor, if I may just quickly address bond.
You may.
Your Honor, my understanding is that the bond is currently set at $25,000. We are asking for a 10% provision on that. Ultimately, we are asking for a PR if the court would consider it. My client can stay with his mother in Belleville. He can willing to maintain no contact with the complaining witness who lives in Ypsilanti. So he has no reason to go to Ypsilanti. Otherwise, he is responsible for financially supporting 2 children at this time, and he's willing to do a strict home confinement and any other condition that the court feels is appropriate. We are just asking for a 10% provision, if nothing else.
Response.
Reduction of bond. In this case, the 15-year-old child of the victim called the police to say that the defendant was threatening his mom. When police came, the victim said she didn't know why they were there. Tried to get the 15-year-old not speak to police, but he told police that the defendant trusted guns to his mom's head, and at that point the victim refused to let the child enter the house. So I have serious safety concerns. Should he be released, or is he be hearing information as well?
Anything else?
Nothing further.
Motion for bond reduction is denied. Bond will continue. Thank you.
Okay.
Court does call the case of the people versus Jaqueline Cleaver.
Honor, Assistant Public Defender Alexis Kumar appearing with and on behalf of Mr. Cleaver. Mr. Cleaver, could you say your full name?
Jaqueline Lavelle, please.
Thank you.
Say that first name. Jaqueline. Okay.
Your Honor, I believe there should be a plea form in the.
There it is. The plea form indicates that the defendant would be pleading to an added count 4 of use of a controlled substance, a 1-year offense. Upon a successful plea to that charge, counts 1, 2, and 3 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Yes, Your Honor.
May have him sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give to be the truth, nothing but the truth, so help you God?
Yes, sir.
State your name.
Jaqueline Lavelle, Cleaver.
Sir, it is this court's understanding that you're going to plead guilty to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form today?
Yes, sir.
Any question about those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
Yes, sir.
Which one?
Probation.
All right. Were you on probation at the time of this offense?
Yes, I was already on. This was a couple years ago. I was already on probation. This case,
Just want to check something. All right. So you were on probation at the time of this offense?
Yes, I was already.
All right.
No, I wasn't on it. I caught the case and then it was like PFI, pending further investigation.
Okay, so when this case was committed, were you on probation?
No, I wasn't.
No, all right. Does anybody promise you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense, sir?
Yes, sir.
On the date of September 24th, 2024, location 2125 Glencoe Hills Drive, Pittsfield Township, Washtenaw County, State of Michigan. Did you have hydrocodone in your, or cocaine in your possession, sir?
Yes, sir.
All right. And did you know you had cocaine?
Yes, sir.
Had you used it?
Yes, sir.
All right. And you knew what you were using was cocaine? All right. Sir, if I accept your plea, I do have to advise you that if you commit misconduct as defined under the Michigan court rules between the time of my acceptance of your plea and the time of your sentencing, the court would no longer be bound by any sentence evaluation or recommendation. and you would not be permitted to withdraw your plea. You understand that?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 4. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
December 10th at 9 a.m.
December 10th, 2025, 9 a.m. That is before me. Bond will continue. All right, sir. Thank you. Sir, on your way out down the hallway, my probation department is on the left-hand side. Stop in there and just let them know that